Hi, I'm Jarrad Brown, Australian expat financial planner based here in Singapore, and welcome to my video series. Today we're going to talk a little bit about US estate tax for Australian expats. Now, what we're going to look at is exactly what it is, when it applies, what some of the figures you need to be aware of are, and what you can potentially look to consider to do. So let's dive right in and start with exactly what this estate tax is and how it might apply to you. Now, it's important to realise that we're talking about US estate tax here. Now, the top tax rate that can be applied to your estate is 40%. That's 40. Now, in Australia, we enjoy the privilege of not having inheritance or estate tax. That is, of course, something that could change in the future, but for now, we can be lucky and rest assured that we don't have an estate tax in place at the moment. Now, the important numbers to bear in mind are that if your estate, so if you're a US citizen and resident, then you have an allowance of up to $11.58 million. So quite a large allowance before estate tax starts to apply. However, if you're a non-citizen or a non-resident, like an Australian expat with US shares, we'll look at some case studies shortly, but let's just say you're an Australian citizen living in Singapore, you've got some US shares, then your allowance is only $60,000 US. So what you've got to be aware of is, are you a US citizen or a US resident as well? Do you own US assets, and where are you currently resident? Because where you reside is going to dictate how much of an estate tax allowance you have, because it comes down to the double tax agreement. Now, before we get into that, let's have a look at when this could apply. So there's a few common occurrences and common times that this could apply. You could naturally be living in the US, either as a US citizen or US resident. Naturally, that estate tax is going to apply. You could be an Australian citizen married to a US citizen, so naturally there's going to be some estate tax exposure there as well. You could be an Australian citizen with US assets, which we'll get into, or you could also be someone with business exposure, so companies set up operating in both the US and Australia potentially. Now, the most common scenario that we see with our clients is Australian expats living and working in Singapore or somewhere else with US shares. Now, commonly that will come as part of their employment. It might be the employee share purchase plan, shares that they've been awarded as part of their remuneration, and naturally these shares can build up quite quickly. Some of the share incentive plans through RSUs and various other incentives are quite generous. So if you start exceeding that $60,000 limit as an Australian living in Singapore, you could be therefore exposed to that US estate tax. Now, a couple of things to be very mindful of here, and then we'll get into what you can think about doing, what some of the options look like in terms of minimising that exposure. Now, it's a little bit tricky if you're an Australian expat living and working in Singapore and planning to go back to Australia. And here's why. The agreement between Singapore and the US means that your limit is just $60,000 US. So that's the amount of money that you can have invested in the US through US shares or otherwise before you get that estate tax exposure. However, if you move to Australia as an Australian citizen, your limit is now $11.58 million based on the double tax agreement between Australia and the United States. So what do? Do you just wear the risk while you're in Singapore with the view that you'll be back in Australia soon and therefore have a larger allowance? Or do you start thinking about moving those shares around, selling them, etc.? So let's have a look at some of the options that you've got. Now, the first one, and perhaps the most obvious, is you can simply wear the risk. You can hold the shares if you believe they're good value, you don't want to sell them, you don't want to move them, and you understand that you've got that estate tax exposure. Now, naturally, estate tax applies when we pass away, so you may think, look, I don't really care, or I've got insurance to make sure that my family's looked after in the event that estate tax applies, or we've got plenty of other assets, so the family and surviving loved ones will be perfectly fine. Naturally, an option to consider. Your next option is to consider selling the shares. So if they are part of an employee incentive plan, you can consider to start to reduce your holding and potentially even keep yourself at that $60,000 limit. Now just remember to check on the limit each year because it can change over time. Your third option is you can look at changing the ownership structure of those shares. You might wrap them in a trust, in an insurance structure, a company structure. Here it is very, very important to make sure that you seek professional advice because there are some vehicles, there are some beneficiaries where the estate tax will still apply even if you've wrapped it in something else. So make sure you're getting qualified advice from a professional, a US tax advisor or US financial planner, and make sure that what you're setting up is right because some of these structures, in fact most of these structures, will often have both setup and annual running costs. So a common one to be very aware of if you're looking to invest in the US stock market or ETFs, whatever it may be, or you're being awarded US shares as part of your employment, just be very mindful of that estate tax. If you have any questions at all, please do drop me a note in the comments. If this has been helpful, please remember to subscribe, turn the notifications on. Really appreciate you tuning in, and I look forward to seeing you next time.